we'll do these out of order. So Charles, if you don't mind, SB 120, enacting the Municipal Employee Whistleblower Act to provide statutory protections for municipal employees who report or disclose unlawful or dangerous conduct. Could you give us a bill brief? Thanks, Charles.
Thank you, Chairman, members of the committee. Senate Bill 120 is a sister bill to House Bill 2160, and this bill enacts the Kansas Municipal Employer Whistleblower Act, which is quite similar to current law that protects state employees. It provides legal protection to employees who would report or disclose unlawful or dangerous actions, both current law and also the bill would apply to municipal employees that an employer cannot prohibit or take disciplinary action against an employee for engaging in certain conduct. This bill only applies to employees of a city, county, or school district. That's how municipal is defined in the bill. Disciplinary action is defined to include dismissal, demotion, transfer, reassignment, suspension, reprimand, warnings, and withholding of work. So the conduct that a municipal employee would be protected from includes discussion of agency operations, including matters pertaining to public health, safety, and welfare with legislators or auditing agencies, reporting violations of state or federal law or rules and regulations. The bill provides additional protection to what is in current law for state employees with respect to disclosing malfeasance or misappropriation of money and disclosing substantial and specific dangers to public health and safety. So as with state law under SB 120, an employer does have some exceptions. An employer can require an employee to inform the supervisor of any information provided to a legislature or auditing agency. An employer can require the employee to follow all official leave policies unless the employee is requested to appear before a legislative committee or auditing agency. An employer can prohibit an employee from expressing their own personal opinions as those of the municipality, and the employer can take disciplinary action if the employee discloses information the employee knows to be false or recklessly disregards the truth or falsity of that information, or information that is exempt from disclosure under the Open Records Act, or information that is confidential or privileged. The bill provides that an employee who is aggrieved by a violation of the Act may file an action in district court within 90 days for damages, equitable relief, court costs, attorney and witness fees. As I mentioned, this act is only applicable to counties, cities, and school districts, and each such municipality is required to post a copy of the act in locations where it can reasonably be expected to be viewed by employees of the municipality. If enacted, this bill would become effective on July 1st, 2025.
Thank you, Charles. We have questions. Senator Petty.
Thanks, Madam Chair. And Charles, is this a different definition for municipality than we have in other places in statute?
Senator, yes. There are, I think, probably numerous definitions of municipality, but this one in this bill is specifically limited to counties, cities, and school districts.
So so there's multiple different definitions in different parts of our yes. statutes, but this one, okay. And the second question is, how would the employer know what an employee had brought forward as a whistleblower?
So the bill does provide that an employer can require an employee to inform the employer regarding the substance of what they are going to say. So if you look on page 2, lines 7 through 12. Does that answer your question, or is that a little bit not quite what you were looking for?
Well, I read 7 through 12, but doesn't that say it, does it prohibit the supervisor from requiring to inform the supervisor?
No, you'll see the lead-in language there on line 6. This section shall not be construed to prohibit.
Okay, so they wouldn't be prohibited from asking about the information that had been disclosed. And so that would, and I know with the punitive action that it's included within this bill in lines 29 through 38, so they would have had access to, they would have the ability to know what information a supposed whistleblower had provided in some way.
Yes, pursuant to the paragraph there that we just discussed.
Thank you.
Thank you, Charles. So we have two proponents. We have one in the room and one on WebEx. So first up is Representative Carrie Barth, Kansas House District number 5. Welcome to the committee, Representative. Thank you.
Thank you, Madam Chair Bowers and honorable senators of the Local Government Committee on Transparency and Ethics. I'm Representative Carrie Barth. I'm from House District 5. I represent portions of Douglas County, Johnson County, Franklin, and Miami counties. And I wish I was not standing before you today. I wish there was no need for this bill. That's probably the way most of our bills are. But unfortunately, we have some folks that are in government positions doing things that are unethical, and there's corruption. And I think most employees that work for the local government, for counties and cities and school districts, they love their jobs. And these are really important jobs to them and in their communities. And so this is there to protect them when they do discover something that is of unethical, illegal, or proper misuse of taxpayer funds. I do believe this is a necessary step. I am the person who generated this bill. I utilized, and we had your vice president reach out specifically because there was a need for this across the board. I've had lots of requests from folks to do this. I took both the federal, I worked with the revisor to bring federal and state to make it really work for Kansas. So the language that you're seeing is pulled from federal and state existing statute. The reason why we chose these 3, the counties and cities and school districts, because those are the most 3 that I've heard the most issues with. And I also think the narrower definition of those 3 gives it a lot better chance of passing, because there are I think around 1,000 or so governed entities that this could apply to if we opened up the door. And I just feel like narrow defining it in this way makes sense. So thank you for having me speak on this bill today. We do have these laws already for state and federal employees. I really just want this to also apply to the folks that are in local governments. I provided an outline of some of the issues, and you'll see in a lot of the written testimony, several of these issues I've listed out in my written testimony, you're actually going to find those proponents' written testimony specifically. This is one of those tricky things where sometimes I feel like I cannot share everything with you because we do not have a law protecting these people already. So without being able to disclose names or positions or school districts or specific counties necessarily on some of this, I'm a little more vague than I would like to be. But a lot of this, you can actually Google it and you can find the articles written on it with specifics around each and every one of these bullet points here. The first one that was one of the things I found out was over a year ago, Neosho County's attorney was accused of soliciting nude photos of 50 women. This was known. It took some time for this to come to fruition. And, that's something that someone as a whistleblower should be able to feel comfortable coming forward with, because that is something that is considered to be illegal. In Bourbon County, there was a county finance director who was being threatened. I actually became in contact with this person last year. I put them in touch with our Attorney General's office to get them some support and help. And this is one of the reasons why the bill has come to fruition. You're going to see that person's testimony in writing as well. Since then, when that person told me their job was already being threatened, since then that person's job actually, the budget was eliminated. And all we're asking for is just to do the right thing. We just want there not to be corruption. We want that person to be able to come forth and be taken seriously as long as they're being honest and truthful and have facts and data. This bill is not to protect that person who is trying to just get out of something that they've done wrong because they're on the path of being fired. It is not for that person. Also in Leavenworth County, there's lots of issues with improper use of taxpayer funds. I know that's being potentially investigating at this point in time as well. We have a Kansas school district threatening a teacher's job for individual liberties, where they're being told by the building principal to not say things to the parents as well. We've got a group, I think it's over 25 between businesses and individuals, suing the Douglas County Commission, where there's a Douglas County employee whistleblower that is also named in the case, where they're suing a county commissioner that's been added, that's accused of taking improper behind-the-scenes actions along with not recusing themselves for substantial personal interest. I specifically have more in-depth information on that case as well, because I have been in the county commissioner meetings, I've been in the planning and zoning meetings on this issue, and what they're stating is factual. So I've had others come forward on this bill. I've had quite a few senators as well as representatives come up to me saying this is a good bill. This is something that's needed in our state. We really just are looking to minimize the amount of unethical behavior and corruption. I know this will not stop all of it, but I really like to think that having something in place would actually help with minimizing the issues that we're seeing and provide another layer of protection for people who love their jobs, who are just trying to do the right thing. So thank you again for your hearing this bill today and listening to my testimony, and I will stand for questions at the appropriate time if you have any. Thank you.
Thank you, Representative. I see Senator Fascadeau.
Thank you, Madam Chair. Representative, you stated that this wouldn't protect that whistleblower from retaliation of bringing the issue forward, but then how exactly would be the mechanism to hold or to not have that person be retaliated against and then hold the bad players accountable?
All right, thanks, Madam Chair, and thank you very much for that question as well, Senator. So it is there to protect the person's job who's bringing forth factual information. It is. So they can bring it forth, that information, that gives them the opportunity to have job protection to bring the information. Most of the time, people are just holding it and not saying anything. And it continues to happen until it gets to the point where it becomes what you're seeing on this paper here today. You have a second part of your question, I think, too.
Well, Madam Chair, if I may, just for clarification, so okay, I know that the legislature is not doing what they're supposed to do. I go then to the president of the Senate or the governor, and I say what I know, what I've seen. So now, how is this legislation actually going to protect me? Do I tell other people, hey, I'm going here, and so if I get fired now, this is why? So is that the language in the bill? Who do I get to tell?
Yeah, and I think the reviser also was trying to convey that, so appreciate the question. They actually have the ability to tell their supervisors or anyone of authority within their organization and folks within their organization to be able to come forward with what it is. You know, with the person I gave you the example from Bourbon County, I put them in touch with the Attorney General's office so they can file a complaint there for formal investigation. So there's multiple layers of what they can do. But ultimately, if their position were to be eliminated or there were retaliation, or let's say their property taxes got egregiously raised because they were pushing back on something, which is another case, another person reached out to me since this hearing came up where that actually happened. It provides them some protections against those. And then if they do get those positions limited, then it gives them cause for being able to file for a court hearing.
Madam Chair, thank you, Representative. And Charles, though in the language, so is each employer throughout the state agencies, et cetera, so they'll be notified that they're going to be in trouble if they retaliate against the person? I'm just trying to see exactly how, if that makes sense. Thank you, Madam Chair.
Would like to take a stab at that, Charles?
I'm not quite sure I understand the question. Is, you know, with respect to notice to an employer? So, you know, obviously the employer would be aware of the bill if it was passed. There's also that provision that the employer actually has to post notice of the provisions of the bill. So, you know, they would know about it through I guess, posting it. You know, otherwise, you know, there is also that paragraph that we had discussed earlier that provides that an employer can require that an employee inform the employer regarding legislative or auditing agency requests for information submitted to such municipality or the substance of testimony made or to be made by the employee to legislators or the auditing agency on behalf of such municipality. So there is that provision that an employer can request that information.
Senator Clifford.
Thank you, Madam Chair. I was reading on the statute of limitations sort of on this, the 90-day. It seems like, say in the instance of a school teacher, there's a DEI policy or something, and then it's rolled out over 6 months, say. I would think the court would then, you know, there would be an argument, well, the teacher knew 6 months ago, so we're past the 90 days. So I guess I'm asking why choose 90 days, but because I would like to see it longer. So thank you.
I think that's why it's in committee for you guys to have that ability, Madam Chair and Senators, to amend if you feel necessary to accommodate for those situations.
Thank you, Representative Barr. Thank you, Madam Chair.
Well, thank you, Representative. We'll move on to our next proponent if you'd like to stay with us, if you can. So next we have WebEx, Catherine Ellsworth, a private citizen, Douglas County. Welcome to the committee, Catherine.
Hi. I submitted a can you hear me?
Yes, and
Okay.
I think, yeah, very well too, by the way. So I think if I can have you, we have your written testimony, maybe around 5 minutes, so we can move
Okay.
on to the second bill later. Is 5 minutes good for you?
That's plenty. I don't want to
Oh,
belabor.
wonderful.
I don't want to belabor the point. My written testimony kind of went down a rabbit hole just to emphasize how important it is that that there is some sort of way to address some of the bad things that are going on at the level of county government, even though protecting a whistleblower is kind of fixing a problem after the fact, but it's, you know, it's obviously necessary, that and also some of the core things that are going on at the State House. So I just want to really drive home that I only know about county government, but that there needs to be some sort of protection at the county level. For example, we have a lawsuit, you've probably read this week in the Topeka Capital Journal about the lawsuit in Jackson County against some of the commissioners. It's an amicus brief and then a related lawsuit against the county commissioners there for facilitating favorable regulations for a developer. And that's a lot of what's happening in Douglas County as well. But in Douglas County, just kind of a little anecdote, I had had my suspicions about the county commissioner that's involved in this lawsuit. And so I submitted a KORA. And then I went to a meeting, and there'd been an interview, a radio interview with the same commissioner, and she was saying how KORAs were just a waste of taxpayer money, of course. And at this meeting, and so I thought she was talking about my KORA, but it was one of the litigants had filed a KORA. My KORA result had nothing in it. It was just gibberish and junk, and they threw a bunch of things in some big PDFs. But the KORA that the litigant had filed, she had been contacted by a whistleblower. So she obviously knew how to shape her KORA. So because of the information that had been provided by the whistleblower. And so obviously that was enough information to build a whole lawsuit upon. So if she hadn't had that whistleblower, nobody would know. So it's really imperative that there be some kind of protections in place for these people that are really protecting Kansans. So thanks for your time.
Well, thank you, Catherine, for joining us. Let's see if we have any questions. Committee, do you have any questions for Catherine? Well, wonderful, and you did great on your time. Thanks for accommodating us as well.
Well, thanks for letting me speak.
Let's see, I do want to bring the committee's attention to the list of proponents that are written only, and you can see those on your agenda. And we have an opponent that's written only, and then we have two neutrals that are here in person. So Jay, you're first on the list. Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. Welcome to the committee, Jay.
Good morning, Madam Chair, members of the committee. I am Jay Hall, Deputy Director and General Counsel for the Kansas Association of Counties. I want to start by making it clear that KAC supports whistleblower protections. That's why we are neutral on this particular bill. We do have some questions about how this particular bill is shaped because, as you heard the reviser say, this bill is similar to the state and federal laws, but it is not the same as the state and federal laws. And that's really where we have the questions and why we are not a proponent of this bill and instead are neutral. Again, we support whistleblower protections because if there's illegal conduct going on, that should be rooted out. But as you see in my testimony, I talk about the fact that typically whistleblower protections kick in when there is some sort of illegal conduct or some sort of rule that is being broken. That's typically the type of behavior that you can report to get whistleblower protections. In the absence of that, things get a lot more murky when you start talking about protecting things, because then you could have a situation where somebody simply disagrees with a particular policy that the city or county may have. And as a result of that disagreement, they could now be covered under this because this is a broader definition. That's our only real concern. Like I said, we fully support individuals being able to root out any sort of illegal activity because that is necessary to make sure that the government is serving the people. So with that, I would stand for questions.
Jay, what if you hang around a second and let's go to our next opponent, and then we'll ask questions, or neutrals, and we ask questions at the same time, in the sake of time. So you'll be up first, Senator Clays. So now we have John Goodyear, General Counsel, League of Kansas Municipalities. Welcome to the committee, John. And then you stay up there and we'll see who we direct our questions to, okay?
Thank you, Madam Chair, members of the committee. Good morning. My name is John Goodyear. I am the General Counsel for the League of Kansas Municipalities. Grateful for the opportunity to appear today. Similar to Jay and similar to the Association of Counties position, we aren't opposed to whistleblower protections. That's why we came in neutral today, to just call some attention to some deviations from the State Act and to question why those are there, and to point out why maybe we should tie closer to the state act. Just as a starting point, most of the information that a person can share is going to be protected by the First Amendment, and we think that that's good, and we think that provisions in this bill provide the appropriate protection for the employer as well. So this is a good starting point. But I want to call attention to a couple of places where the bill deviates from state law on state employees. There are a couple of different protections for information that would be shared that aren't included in the state act, specifically subsections 4 and 5 aren't found in the state act. We question their need. For one thing, it's our position that any information shared under 4 or 5 would be protected by protections 1 and 2. Those are pretty broad protections. Just looking at number 4 specifically, I will say malfeasance isn't defined, misappropriation isn't defined, and like Jay said, where we're talking about true violations of law, those are great, but where we're talking about if it's something that I don't like the way that my city or county is spending money, which as a resident, I'm sure that's happened to all of us at some point, but that doesn't mean that use of money is unlawful. So maybe tightening up that language or just tying it back to those broader protections in C1 and C2. The second thing I want to point out, and I didn't point it out in my written testimony, but it was addressed in the written testimony of Overland Park, is that within the state act, there is an administrative proceeding that takes place prior to going to court. And this is there for a couple of different reasons, I would guess. I wasn't here when that law passed. But one is to mitigate costs of litigation. An administrative proceeding is going to be less costly than going to court. But secondly, we have chains of command in place, that we have procedures in place for reporting specific violations of law up the chain of command to give our employer the opportunity to address those. And if those aren't addressed, that's when whistleblowing should take place. State employees report it to a state agency, I think it's the Civil Review Board, and it gives an opportunity to address it before we end up going and litigating. So we would ask that a similar opportunity be afforded to municipalities to help us to mitigate those costs. So like I said, neutral. We want to make it clear that we don't oppose protections for whistleblowers, but just some questions that we think need to be answered before this legislation moves forward. And I'll stand for questions at the appropriate time, which I think is now.
Okay, you got to think, that's right. Thank you, John. Senator Claes, would you have a question for Jay, or you choose?
Well, yeah, I think it's for Jay, but it may have been somewhat covered by our last speaker. Sorry, I forgot your name already. But I too would have the same concerns as with something like this. I'm totally supportive of the intent of the bill, which is to protect whistleblowers. It's really that gray area between a whistleblower and a malcontent, and making sure that we're keeping those two clear and separate from each other. So my question to you, which it seems like he mentioned 4 and 5, was there something specific about this bill that you thought would clean it up so that the malcontent doesn't get viewed as being a whistleblower?
I think the sections in 4 and 5, particularly so. Because we don't have the definitions of malfeasance and misappropriation there, is it just a simple disagreement of, I think we should be spending less money on Parks and Rec, or I think we should be spending more money on public health? That's a disagreement. That's a reasonable disagreement to have. But that doesn't rise to the level of whistleblowing, because there's nothing illegal about saying, well, we have a different priority, we're going to spend less on this thing or that thing. And so we just want to make sure that it's clear what is the difference between a disagreement and an actual illegal action.
Madam Chair, can I follow up? Okay. So, yeah, I get that, and I read this, and you're a lawyer. I'm not a lawyer, and when I read this, I don't read it that way. It looks like, and I don't have a dictionary in front of me, but malfeasance and misappropriation do sound like things that are not opinions myself. Is that not how a judge views those? Or and let me, so we don't have a back and forth. what would you suggest we do besides just striking these? Is there better language that gets to the same thing? Because I get the intent of this, and in fact, like I said, to me, I don't see the ambiguity that you do, but I am concerned about it.
So when the way the court would view the language is that they would look at all of this, and when you see Section 2, which we have no problem with Section 2, it's when you report a violation of state, federal law, municipal resolution, or ordinance, or any rules and regulations adopted pursuant to such law, resolution, or ordinance, that's covered in Section 2. So if you are doing something that's a violation of Section 2, we have no problem with that. The thing is, now we have Section 4, which is a separate section that seems to be an expansion beyond what is listed already in Section 2. And it's unclear what that expansion is supposed to reflect, because if you are doing something that's a violation of a rule, if you're using money that is in violation of a rule, then that's already covered under Section 2. And I don't understand what the malfeasance or the misappropriation that's covered in Section 4 would then be for. That's really what I'm driving in at there. Okay.
And committee, I've just got word that the proponents for 194, which is our second bill, would ask us to postpone the hearing and an exempt bill so we can continue to ask questions about this one too, so we don't have to feel so rushed, if that's all right. Jay, I could ask you, or even John, House Bill 2160, is there a companion bill in the House that goes with this?
Yes,
Is there?
House Bill 2160, which I
Okay.
think the hearing is tomorrow now.
It is.
Okay, there is,
And I believe it is exactly the same as this bill, word for word, so.
okay. Do you have any other questions before I hop in? So Jay and John, if we remove 4 and 5 that you have in your testimony specifically, does that take a lot of the angst out of this bill for you? If we mirror it more federal and state, are you still neutral, would be my question.
I would still be neutral. It does help with some of the heartburn, and it not necessarily against. I just don't know what they add, and to add to what Jay said, a court, as they're looking at that, when they interpret laws, they assume that there aren't redundancies. So they assume that they don't mean the same thing. But I think that they two would capture anything found in 4 or 5. Just the second thing I'll point is the ability of the state to go to an administrative proceeding prior to going to court. Something similar to that, or some requirement or some acknowledgement that cities do have procedures for reporting violations of law. Sometimes we inadvertently violate the law. We don't know that we did, and giving an opportunity for the employee to report up the proper chain of command, the city or county or school district to address that, I think is important, and that would remove all heartburn from the bill for me.
So was I hearing like an amendment that would require administrative first?
And I'm not sure what that needs to look like, and I'm happy to work with the proponents of the bill to make sure that I don't deviate from their intent either. But some acknowledgement that there is pretty typically a procedure for reporting violations of law internally. And of course, like if where their supervisor, where their direct report is the person that is violating the law, they should have mechanisms in place for going to the governing body or going to an outside body. So just some acknowledgement that there is typically an internal procedure. Where there isn't, it would make sense to go directly to a court or tribunal. But just some acknowledgement that there's often an internal process in place as well.
Okay, Senator Titus, terribly sorry. It's kind of like Bowers and Bowser.
I understand.
So Senator.
Thank you, Madam Chair. To your last point, Mr. Goodyear, isn't there some risk by forcing them into an administrative channel where they may already have a hostile relationship, or the person in their chain of command is high up where he could squash these sort of reform things from getting to a commission or a council? To me, it seems like forcing that channel and not allowing an off-ramp sort of in a circular way defeats the purpose of this bill.
And thank you for the question, Senator. And I acknowledge that thought process, and I think there is validity to it as well. But where they report it or where there's a hostile response, that's when they report it outside the organization. That's when they take advantage of the whistleblower protection. And that's what we see in other states where they have these protections, is that there is some requirement that they go first inside. And I don't know what that needs to look like, and it does, but just some acknowledgement of an internal process first. And I understand, like, maybe that increases the potential that there is adverse action against them, but then that strengthens their claim as they bring a claim.
Just to follow up, I mean, my concern would be if you've ever been involved in one of these, if the adverse claim is you're fired and now you're not getting paid and you have to hire an attorney to try and get, your recompense, it can put an employee in a very difficult situation where they may not want to blow the whistle because they can't afford to, get restitution for the adverse action.
I understand. I understand that maybe these two talk. They may have an idea that I don't have yet.
Yeah, so I used to work for the state, so when there's an adverse action at the state level, it goes to the Civil Service Board. So counties and cities and school districts.
Now, that would only apply to classified employees.
Right.
So for most state employees, that's not where they get that protective
Right.
blanket right away.
So, but we don't have necessarily a mirror process at the city, county, or school district level. But we would probably need to create something like that if we were to create that, so you're not just going to the county commission, or the city council, which I think is the concern you're expressing.
Well, the council maybe. I mean, you said administrative process. My concern is that it would only go to city administrators, not the council. That's what I heard when you say administrative.
I think it would depend on how it's written, and if it needed to go to the governing body, that would, if that eases the heartburn on that side of the issue, we're open to it.
The other thing is based on the size of the community, the sophistication to be able to manage this process, because these are pretty delicate if they're legitimate claims. So, things to think about if we move forward. Thank you.
Question, Senator Petty, you had a question mark on your face.
Well, I had a question,
Senator
but
Petty.
actually Jay answered it because he did bring up the process, but then it was clarified that it was just for certified employees, not, you did mention that there is a process right now at the state level. Yes. And that was my question, that what was in place at the state level.
Yeah, we don't have a mirror process for that at the county level at this point, so that would be something that we'd either have to create within the framework of this bill, or we could utilize some existing process. Otherwise, I think it would send a lot of things to court. I think the proponents did mention that several of these things are in lawsuits right now as a result of that. And one thing we know about lawsuits is those can get very expensive very quickly. So we don't want to have a chilling effect because you have to automatically go to a lawsuit in order to get these things solved and to enjoy the protections under the act.
I understand that. Thank you.
Okay, I don't see any other questions. I think we've flushed out a lot of questions and details on this idea that I wonder if the proponents and opponents could work together, and you also have your hearing over on the House side to even perfect it more. Monday will be our last day to meet before turnaround, so if you all can come to a conclusion and let us know there's some middle ground here, then we could work the bill Monday, so we can stay in touch about that. But if you all would work together, I'd really appreciate that. And we can also listen out for the House hearing as well. All right, I don't see any other questions, so we'll close the hearing on Senate Bill 120. And thank you for coming in, and thanks for spending the time with us, Representative, and Catherine online as well. And then no meeting tomorrow, but Monday we'll meet and go ahead and review the bills that we have in our folder, and we'll see which ones, if there's interest in working those on Monday. So thank you very much, and we're adjourned.